straight through. So I don't fuck around because tomorrow's never promised, and I have a shit ton of information to give you guys to expedite your learning curve. So I will go until I crash. As for the other people that are joining us, special speakers and guests and things of that nature, they may be limited on their time today, so we'll let them get up and say what they have to say and present their information. And then, of course, if those special guests have something else to do, they can open up the floor for questions. We'll ask that you guys stay on subject matter. Like today, we're focusing on territorial jurisdiction, proper venue, how to identify a proper venue, how to challenge venue and jurisdiction, um, territory, impersonum, subject matter jurisdiction. These are all very, very, very key and quintessential things that need to be addressed. And so when you guys are asking questions of the speaker, stay specific to the subject matter they speak on. Don't embellish and try and talk about mortgages. We're not here to talk about mortgages today. We're going to talk briefly about banking only because everything they're doing is banking. But we're going to try and help people get a firm foundation of the sound doctrines and principles. So Cool Fox and I conversated for about a week trying to just decide how to start, and foundation was key. And so we're going to be talking about treaty. And we felt that everybody has interacted with driver's license or knows somebody that's got a driver's license and this right to travel issue. So what better issue to touch than something that everybody's pretty well familiar with and acquainted with? So that's going to be our starting point. And then we have some follow-up seminars that are just going to be freaking amazing. But understanding the foundation and the fundamentals is key. And this right here is going to give you the foundation, which is fantastic. And from this, you'll be able to look at other things that they're doing and realize, oh, that entity is not government. They went into cooperative agreement for federal block grant funding. They're nothing more than ministerial administrators trying to suck me into their corporation as an employee. I'm not subject to their policies and procedures and horse shit. And this isn't a judiciary. This is an administrative hearing for which the administrator is being bought and paid for by these organizations, which is emoluments violations and everything else. But until you understand those things, there's nothing you can really do to touch them. But so we're going to lay down the foundation with the DMV, the AAMVA, the BMV, the Attorney General, the Secretary of State, the Governor. I'm going to bust down the Constitution for you guys because what you were taught in school about the Constitution is wholly inadequate, and not only is it inadequate, it's incorrect. So we're going to go through that real nice and slow so everybody understands what's going on. You were never taught about the four organic laws. Everybody wants to preach about the Constitution like it's this great document that liberates everybody, and it couldn't be further from the truth. It does if you know how to read it. If you don't know how to read it, it's structurally designed and engineered to ensure that you have a false sense of knowledge with conviction to such a degree that it enslaves you and makes you subject to them. And one of the first preconceived notions of most people is that the Constitution grants them rights. The Constitution doesn't grant you a fucking thing, not a fucking thing. And so we're going to get deep into it. And I can tell you this with firsthand perfected knowledge. I mean, I've had somebody sit on the bench before and looked at him and said, the United States is lawless for all intents and purposes. And he looks right at me and goes, "You're 100% correct." He waited for 2 seconds for me to walk out the door. And instead, my dumb ass sat there, because I was in disbelief that he agreed with me. And then he looked at the prosecutor and said, "How's the state wish to proceed?" And off they went with the running of the game. So, for me to be intuitive enough to understand that it's lawless for all intents and purposes because contract creates the law and equity follows the law. And until I consent and agree, there is no law. And so they're arbitrary and capricious. Everything they're doing is arbitrary and capricious unless it's to bolster my life, liberty, pursuit of happiness, and enjoyment of property. Anything else other than that is arbitrary and capricious. Absent a victim, there is no crime. So if you're charging me under some benign statute, code, city ordinance, rule, or regulation, produce the damn contract that I've entered into where I knowingly, intentionally, and willingly waived my rights and agreed to be subject to policies, procedures, rules, and regulations of some benign corporation masquerading around as government. So I know I went 100 mile an hour through that, but by the time we're done with this, you guys will be able to look at other things such as DHHS, the Social Security Administration, the United States, the banks, things of that nature, and you'll start to see what they did and the importance of the overturning of the Chevron deference case. That is monumental and huge. And I hope people catch on through this class and start to utilize that as an affirmative defense, at least if nothing else, seated in your mind that you, absent your consent, are not subject to any of these corporations masquerading around as government. And for example, the Federal Reserve, the name resembles something that would sound to be like government, but it is in fact not government at all. And there are so many of these organizations out there where Congress creates loose legislation and leaves it up to these organizations to create the rules and policies and allows things to go in to administration and arbitration, where people are subjected to rules, regulations, and policies of these entities, and they believe it's law when in reality it's not law at all. And every corporation registers with the Secretary of State, and they agree to be bound by Title 26, the Internal Revenue Manual, the state constitution, the federal constitution, and all the treaties and laws thereof. Uh, and it's really important because that's how you can liquidate these corporations that are doing these things that are masquerading around as government. As soon as they trespass on your right and you give them notice of cease and desist, notice of liability, and they continue on, liquidate their asses, liquidate them, and you can do that. Um, the decision becomes whether you're going to do it on the public or the private side, whether you're going to go into the exclusive jurisdiction of equity, which equity typically is not where you're looking for financial awards. You're looking for an estoppel. You're looking for a remedy other than monetary. And then, of course, uh, at law in rem, you're going to be looking for those monetary damages and maritime admiralty. But you're going to need to find your standing for that, statutorily speaking. You're going to have to state a claim for which relief can be granted. And we're going to talk about that stuff today, too. A lot of people file claims, but they never provide the remedy. So then they say, well, you filed a claim for which relief cannot be granted. Nobody ever demands a finding of facts and conclusion of law. That's a huge mistake. All right. These people, when you do it right and you know what you're doing, um, they're not going to practice law, and they're going to tell you that they can't practice law or give you legal advice, which is all fine. We're not asking for legal advice, and most certainly not asking for legal advice from people who are incompetent that believe themselves to be learned. But there is a process and procedure for doing things that expedites your ability to um, get your remedy. And remedies can come in many forms, whether it's an estoppel, whether it's punitive damages, and so on and so forth. So we're going to be talking about all of that. But
Oh, I've certainly made some mistakes in my time trying to figure this stuff out. I had a judge once after I give him my paperwork, and this is definitely the pitfall of not knowing how to stand on your paperwork. He looked at me and he said, "Get out of here." And he started giving me a shooing motion and this and that. And I kind of didn't know what to say after that. And I was kind of like a deer in
yep.
headlights. And then next thing you know, next thing you know, I'll get surrounded by two of the biggest bailiffs I've ever seen. And then he's just like, when he saw that I wasn't leaving, and then then I ended up spending that night in a cell. So,
Well, you're going to want to make sure that I'm going to talk to you guys about doing special appearances on paperwork and not going into the court because honestly, the reason I go in there is because what I do for a living is fuck with public officials. I call it entertainment for poor people. I get a kick out of it. I have a lot of fun. I learn a shit ton by their body language and their silence. And I would never advise anybody to do what I do because it's dangerous. And quite frankly, it's stupid, but it's entertainment for me. They pissed on my back, tried to convince me it was raining for so long. I love watching them turn peaked in three shades of green and look like they're going to puke and start worrying about their wife and whether or not she's going to be labeled as an accessory after the fact, so on and so forth. And um, you know, I don't care about materialistic possessions. So once you get over the fear of losing things, their illusion of control disappears real quick. So and the Heavenly Father doesn't put me anywhere he doesn't want me or need me. So there's that.
Hey, Derek,
Yeah.
real quick.
Yeah.
I'm in Orlando and I talked to the clerks. They're not letting you go to the courts anymore. They want to do everything via video, via Zoom or
Yeah.
Webex.
We can kind of address those issues too.
Okay.
It's getting dangerous for them, and they know that. They're gonna ride it all the way to the ground, guys. They're going to ride it all the way to the ground. Um, it's like my first mentor told me, he goes, Derrick, no matter how correct you are, they cannot um, break their composure and capitulate to you. They may do it in dispositive statements, but they're never, ever, ever, ever going to just look at you and go, "You're right." They can't do it. They have to ride the facade all the way and corkscrew it into the ground. And a lot of them are going to meet their meet their demise because of it, because people are becoming learned at an accelerated rate now. And the great thing is it doesn't require violence, guys. It requires knowledge. Knowledge is the most dangerous thing in the world. And the most dangerous weapon you can have is a pen. I'll tell you that right now. Wars aren't won with guns, guts, glory, and bullets. They are won with the swoop of a pen through agreements, contracts, treaties. And so, yes, we have the right to bear arms to protect ourselves, protect ourselves from people that would encroach upon our life, liberty, pursuit of happiness, so on and so forth. But remember, violence only begets violence. If there ever should become a day where that transpires, I would tell everybody to stay in their house for at least 2 weeks while Darwin's theory kicks in and the less than inclined take care of themselves and eradicate themselves. And then at the end of 2 weeks, I would say the wolves will come out to play, and nobody's going to want to be in the streets when the wolves come out to play. So, but I know and I believe uh, that the Heavenly Father has given us a great amount of knowledge that we don't have to resort to violence. We don't have to be heathens. Not saying that if it ever comes to that, that everybody's a heathen, but just saying that sound doctrines, sound principles, and men and women that conduct and carry themselves and lead by example can change history without a single drop of blood being shed. And we know this to be true. So let's hope and pray that it never comes to that, because men and women and children will never be able to look at their aunts, their uncles, their moms and dads the same if it ever does. There's something about that is irreversible, psychologically speaking. So let's try and ascend to the mind as efficiently as possible and help others ascend to the mind and protect one another. Because at the end of the day, we the people are in, excuse me, the people are in power. The free inhabitants are not subject to the legislative edicts, and we're gonna get into that. Rick, how much time do you have today? Rick
I got
Martin?
plenty of time to give to my friends out there, and hopefully we can cover a few things. I know a lot of what I speak about is pretty in depth. It's usually easier for people to read paperwork when they email me. I send them paperwork so they can see it for themselves, and then take the ball and run with it. A lot of things of what you're saying about being in court is dangerous, without a doubt. It takes courage, and that's the one thing I can't teach is courage. And to go up against these prosecutors and these judges is a dangerous thing if you're not learned in how to untangle yourself. And one of the things I've learned is when you have a cop on the bench, or not on the bench, excuse me,
Well, before
on
you get too
the stand.
far, we got to start this out right.
Sure,
Brother Yashua, will you open us up with a prayer?
absolutely.
At one service, brother. Abba Father, we thank the Abba Father for another day one is made, that we may rejoice and be glad in. We lift all the men and women here gathered in this space, and those who are bringing their knowledge to edify us. Guide this gathering in the spirit of peace, and grant Brother Derrick and those he has invited to speak the clearness of mind to reach all those that are here with their clear intent and purpose. Father, one's word tells us that where two or more are gathered, one will surely be in our midst. We thank the most Holy Spirit and set apart Spirit for being with us here today. Let this space and the purpose for this gathering be full of one's grace and peace. Allow one's wisdom and knowledge to pour forth. Let us come against the spirit of division by one's divine spirit. Help us to interact with each other peacefully, and may we be granted discernment in all our thoughts here shared. Bind us with the cord of one's love, that we may come to a greater comprehension, even when we have difference of opinion. Grant us one's favor in this gathering, and use us to one's glory and honor. Our prayers are going up with the assurance that one's wonderful favor will be coming down with a double portion. We ask all this by and through Messiah Yeshua, and all the brothers and sisters here in agreement say,
Amen.
let it be so.
All right. So for those of you that don't know, that's our brother Joshua. He's been with me for quite a bit of years now, and he always starts us out in prayer. Um, and we thank you very much for doing that. He also has a tremendous amount of knowledge, and will be speaking at his choosing. But we're going to start out with Rick Martin. For those of you that don't know Rick Martin has been at this for a long time. He is being shadow banned on the internet. I was trying to search him up the other day and couldn't find nor hide nor hair of him. And I said, Rick, would you like to come out? There are plenty of people that follow me, and I think it's imperative that you tell your story. And it's right up his alley, the conversation of the right to travel and the difference between driving. And Rick has prevailed multiple times now, being accosted against his will. And with that, Rick, would you care to introduce yourself and tell everybody a little bit about yourself for those who are just learning of you?
Thank you, Derrick. I applaud you for what you do, and I'm thankful that you reached out to me, and we can get a conversation going. And I started traveling in 2000. I haven't had a driver's license since 2001. And if you look on the chat, you'll see I put several pictures up there. And one of the first things that you'll see is my Porsche 911 all-wheel drive convertible that Harris County, those that don't know Harris County, that's Houston, Texas. Houston, Texas is the fourth largest city in the nation, the third largest county in the nation. And I prevailed against them. And they actually, I did a video that went viral, and it was with Joan and East, was it Joan Quinn Eastman from Fox News. Actually, we were in Lexington, and she did a video on me when we were showing my Lexus with my license plates, showing the cases that I won against Harris County, Montgomery County, Texas, and San Jacinto County, Texas. And one night in jail cost them, they were the ones that purchased my Porsche 911. And I did that. I wanted to get an automobile that was so audacious so I could drive around the courthouse in Houston with my Don't Tread on Me plates and see how many people were foolish enough to try to pull me over again. They weren't, let me just say, it went viral in Texas right after I won that lawsuit. You'd think Montgomery would leave me alone. They didn't. They learned real hard after they bought me my Escalades. And then San Jacinto County bought me my Lexus. So as it stands, yes, be audacious, go against them. And what you do, and that's where I think everybody, if people are right taking notes, the book that I would tell you that you need to have in your hand is The Common Law Process of Torts, second edition, LexisNexis. That's a very good book to have in your hand. And I should have a bunch of books in front of me right now, but I got everything running around. Another good book to have in your hand. Give me a second. I'm pulling it out so those that can see is this is a thick book, but it's very good. And when you're dealing with stare decisis, that means it's already been ruled on before. And as Derrick said, it's case law. But when you're using stare decisis in your favor of things that have already been ruled on, and say, well, what's the difference? When I've gone in court, what I always try to do is get the police officer on the stand, and I get the police officer to admit that they've had an ex parte meeting with the judge and the prosecutor, which is totally unlawful without me being present. So what you want to do is you automatically want to start tightening the screws on those police officers that are on the stand, and they will admit everything.
So
They
that's
will
a
admit everything.
procedural violation. Is that correct, Rick? What you're attacking there is a procedural violation, a due process violation, correct?
It's both. It's procedural and it's a due process violation. And for them to be colluding with the prosecutor and the cop and the judge without your presence, that's why a lot of times I'll be pulled into the chambers, and the judge will try to trip me up on what my knowledge is. And it's amazing how they'll try, as you said earlier, what they find themselves doing is they will use any type of deceit to get you to acquiesce. And the whole thing is you don't acquiesce. You stand firm on, you have your standing. Show me who's making a valid claim against me. And one, I've been working with a lot of people that are dealing with driver's license issues. Um, I've got a book that I put together, and you guys can get it from me. I don't charge for what I do. Everybody that knows Constitutional Law Group, we don't charge. We work on donations alone, and that's the way we've been since 1996. Now, I do a notice and demand to cease and desist, and it's basically you're challenging subject matter jurisdiction. When we're dealing with the transportation code, that is a federal code that has been adopted by every state. Okay, that transportation code comes from the Constitution, and what they're using is the Commerce Clause. Now, what the states are using is safety issues. So the state, if they start coming at you using the transportation code, hold their feet to the fire with the transportation code. If they try to run off to safety, then you start asking them about safety. And when we have all the statistics of how many people died from DWI accidents from yesterday all the way to 1950, and you show how much everything is dealing with revenue, and that's the whole thing, is when you prove that this is not about a safety issue, and they're going to try to use the safety issue as a driver's license brings safety. You blow it up in their face when you bring all the statistics to their face and show them that no, it has nothing to do with safety. It has everything to do with revenue.
So
And when they do that,
what process, Rick, are you using in order to generate that evidence that's an exhibit in your favor? Are you doing depositions? Are you doing subpoena, ducis tecum, subpoena, FOIA request? How are you introducing that evidence? Are you doing it by way of interrogatories, negative averments, things of that nature?
we do the interrogatories, but we also, when we're bringing things in as exhibits, we're using their own information. And that's where we go to the transportation department. We get a FOIA request, we show what the true statistics are. And when we bring that in, then the prosecutor is going to have to always put the prosecutor in the hot seat. And that's what I'm trying to explain to people, is once you can get the prosecutor to bring forth a case, okay, you hit them with that, okay? Let them tie their own noose by coming at you with the transportation code. Then they're going to try to change gears and try to use safety. But when you show that the transportation code is based on the Commerce Clause, which it is, we've already proven that using their own evidence against them. So that's where you really want to do if you're going to go into court. Other than that, what I would suggest is you try to beat them up with the paperwork and stay out of court. What I was talking about is a notice of demand to cease and desist, and that's stuff that you guys can get from us at no cost. There's a lot of stuff that's not on our website with the constitutionallawgroup.us. There's a lot of stuff because I haven't had an IT guy in a while. There's a lot of paperwork I have that you can get from me personally. I will send it to you. Uh, and like I said, it's how you hold them accountable. And that's where you really have to start making them the ones that are nervous like a whore in church. You want to make them sweat. And with that being said, remember that we always had the power, and it comes from your confidence. And your confidence, and I always say, my courage comes from my faith. And I'm not going to be buffaloed into a courtroom and allow them to get away with what they're doing, because what they're doing is based on fraud and deception. And with that being said, I'll leave the ground open to answer any questions.
I just got a couple questions for you, Rick. Have you ever challenged them on venue, territorial jurisdiction,
I
impersonum jurisdiction? You mentioned subject matter jurisdiction.
Right.
Uh,
Well, subject matter jurisdiction, when you're going on it, the subject matter would be transportation code. And then if you're going to go after them on personam jurisdiction, show me the contract. What you always talk about is show me the contract. Where's the contract that I agreed to live by these set of rules? And, you know, I believe that laws are only there for those that violate the rights of other people. And we should always look at being our brother's keeper and go into a courtroom with clean hands. I'm not always going in there looking at winning a suit, but I will demand to be indemnified if I have been injured. If I've had to spend the night in jail, when I sat there, I never argue with a police officer off the side of the road. I always look for the nearest parking lot to pull into if I'm being pulled over. I put my hazard lights on and I automatically slow down 10 miles from what I was traveling at. And I pull into a parking lot, roll my window down just about an inch, and I will have a conversation with a police officer. And you'd be surprised at how many police officers in the early days before the COVID scamdemic happened, most police officers would actually listen to what you had to say. And when you're sitting there with law books in your hand and you're showing them cases like Sands versus Roe, you're showing them, case law, stare decisis, they will start listening to you. I actually had a police officer, a Houston police officer, who was on the force for 17 years, 3 years from retirement, pulled me over. I pulled into a Home Depot parking lot and we start having a conversation. He goes, "You're the most interesting man I've ever met." And he says, "I get off. Can we have a cup of coffee at Denny's? I'd love to talk to you some more." Never wrote me a citation. We sit down at Denny's and I got my law books with me and I'm sitting him down and he goes, "This is satanic, isn't it?" I said, "Yes, sir, it is." I said, this is putting everybody into slavery. And this police officer, 3 years from retirement, quit his job that day. I kid you not, quit his job that day. And he says, "I can't do this anymore. There is no way as a Christian man I can do this. I'm done." And what he did is he became a carpenter and then he ran for constable of a small county in Texas. And he's been 4 years now, that constable, and he doesn't issue citations except for those that are truck drivers and what have you, those that are actually engaged in commerce. So
you
he's
make a
become
very
an
valid
asset. Go ahead.
you make a very valid point there, Rick. These are our fellow brothers and sisters that are out there, and we don't hold any ill will or animosity towards them, and that's important to understand. In my younger youthful years, well, I was madder than a hatter at these people. And then the good Lord touched my heart, and I realized, these guys have lost their way, and we're supposed to forgive those who trespass against us as we expect to be forgiven for our trespasses as well. None of us are free from sin. None of us are perfect. And, I'm not advocating that you argue on the side of the road with anybody, but being polite and cordial, you tend to,
Be respectful. Yes, be
yeah.
respectful. And,
Um,
when we had all the shutdown going on, I had sheriffs. You know, I spoke to when the first shutdown started happening, and you guys probably knew I had 120 of my special forces buddies come in from all across the country for my birthday, which was a Friday, March 19th. And we decided to have, I got uh, a bar and restaurant that I leased out on the Riverwalk down in San Antonio. And I never even got my deposit back. So we ended up having a backyard barbecue. And that's when Dr. Dave Martin and I uh, got on the phone together and we started working on the mass tort claim that we filed against 49 governors and to reopen America because these mandates were not lawful. And what I called it at that time is exactly what it was. It was a Trojan horse to bring in the economic collapse of America. And that's when I went around the country on my own dime and started helping businesses reopen. And the only time I got arrested was when I went to Michigan, which many of you saw me get arrested in the courtroom. And if you pay attention to the Marlena case, you'll notice they didn't even call the case into record. It was, where's Rick Martin? And I get up there and they're swearing me in, and I'm like, why are they swearing me in? And I had no sleep. We were on Tucker Carlson the night before, and we had gone to a 5-star restaurant, and we had a few drinks, what have you. And I figured because it was Friday, I had until Monday to do a writ of habeas corpus for Marlena's Bistro and Pizzeria. Well, they had already set up, they went 5 counties out. I kid you not, 5 counties out, because I had already talked to the sheriff that she lived in, the county that she lived in. He said, I'm not going to make an arrest. I talked to the sheriff. There's 2 different counties, and the sheriff where her business was, they're only 6 miles apart, but they're 2 different counties. Talked to the sheriffs, and they said, well, we're not going to arrest her. We're not going to get involved. And he says, but we're not going to stop the state police. So I called the precinct commanders, and they said they're not going to arrest her. So they went 5 counties out to find a state police officer to come in and with a whole task force to arrest Marlena for keeping her bistro open. I kid you not. So when I showed up in court the next day, they lawfully they were supposed to bring her to the sheriff's department if they were going to arrest her. But no, they drove her an hour and a half away to Lansing, the capital, to bring her in front of a magistrate. And that magistrate was not even the one that was supposed to be on the bench. Judge Stokes was supposed to be on the bench, but because Judge Stokes only had a year on the bench, they brought in Judge Aquilina, which this is all totally unlawful to be doing to begin with. So, yes, there was territorial jurisdiction that could have been challenged right then and there to begin with. But as it stood out, the judge calls my name immediately, doesn't even call the case into record, and then has me swear in. And I'm like, what is going on here? But I brought up Sims versus Ahern, that there's no such thing as a license to practice law. And you'll see the judge, she's screaming at me, waving that gavel like a lunatic. She goes, Mr. Martin, when I brought up Sims versus Ahern, she goes, Mr. Martin, you open your mouth one more time, I'll give you another 93 days. Well, ladies and gentlemen, I never did 93 days. They put me in jail. They put Marlena in jail. We got Marlena out. They were trying to hold her for those 93 days, but we did close down her restaurant, boarded up the whole shebang, showed it was closed up, and it was only supposed to be $7,500 bond, which I had $5,000 in my front pocket because I figured, it can't be that much to bail her out. Well, they brought the bond all the way from $7,500 all the way to $15,000, but we were able to get her out on Tuesday. This was all happened on a Friday. They kept her over the weekend, and that was during the whole thing when they were keeping everybody separate. You had to spend 14 days in quarantine.
Well, Rick, let's talk about that for just a second, because that violates the Eighth Amendment. Not only is it cruel and unusual punishment, but it's excessive bail and bond. Did you ever make those issues and demand a finding of facts and conclusion of law on how they were doing that?
Absolutely, we did. And let me just say, when you're talking about a corrupt system, they are going to fight you tooth and nail. And if you watch that, she did have a bar attorney, which was Robert Baker, who was on record. He even put himself out there as the only attorney on record. He was there via Zoom. I was there just as assistance of counsel because she has uh, problems with the English language. So I was just going to be there to stand beside her and help her answer questions if need be. And it even said, I crossed out bar attorney and I wrote just assistance of counsel. So they knew exactly what they were doing. And we did a FOIA request. You're going to love this one, Derek. We did a FOIA request. And there was 425 emails between Dana Nessel, the attorney general, and Gretchen Whitmer, the governor, trying to stop me from leaving Texas to go up to Michigan. They were looking at, can we have her arrested before she goes on the Tucker Carlson show? They did not want this out there. This became a political hot potato. And, I will tell you, they tried to assassinate me several times while I was in jail. And
So
that is not a lie.
let me ask you this question.
Sure.
When you find that your rights are being violated, what venue do you press your claim in? Do you do it in the state courts? Do you do it in the county courts? Do you do it in small claims court, or do you go to federal court?
It
What
was I was released on a federal habeas corpus, is what I was released on. My team at the Constitutional Law Group put together my writ of habeas corpus, and then I was released. But I had two federal judges automatically grant my writ of habeas corpus, and that's how I was released.
So again, when people violate your rights, whether they be agents of agency or just people in general, uh, depending on the circumstances, obviously, if it's not an agent agency, you're probably just going locally in your district court, depending on the monetary value if you're doing a statutory claim or versus a common law claim, where you might be seeking equity and injunction or a compelled performance per se.
Right.
So when you're dealing with agents and agency and you won your suits, did your suits go through the entire judicial process, or did they settle outside of court with you? And my question is, did you take them into the federal jurisdiction, or did you take it into the district court or state court? How, how did
when I
you?
was when I was dealing with like Harris County, when I won my suit, it's they wanted to settle out of court because they don't want it on the record. That's the whole thing is when they know that you've got them by the short and curlies, they do not want that on the record because they don't want stare decisis staring them in the face.
So can you
And
explain
others
that
are
to
going to
us a
bring.
little bit? I mean, do you start the court case in federal court and get into depositions and affidavits before they approach you? Was it the insurance company that contacted you for risk management under the liability and criminal liability policies that contacted you and wanted to sit down and have a meeting? Or was it the city and county board that reached out to you? How did that process transpire? And so for people that haven't experienced it yet, if they end up in that position, they kind of know where things are going.
Right. Okay. Like when I fought Harris County, what I did was I brought forth a real claim, a tort claim against Harris County. And I filed it not only with Harris County, but I also filed it with the Secretary of State of Texas. So they knew I was pretty serious about what I was doing. And the next thing you know, the judge is pulling you into the chambers with the prosecutor, and they're going, okay, you want to be indemnified. We're going to settle with you, but we're also going to tape your mouth shut. Basically, is what they're saying is they don't want you to be talking about your lawsuits, and they can come back at you if they settle out of court with you. Uh, they basically tape your mouth once they settle with you. And I said when I was talking to Joan Quinn Eastman, I said it was 250,000. Actually, it was 280,000. That Harris County, my first lawsuit that I won was for 280,000.
So
and
did you
they
bring the
settled out of
claim?
court.
Did you bring the claim statutorily under 1983, or
No,
did you?
no,
Okay,
I actually just brought a tort claim. I did not, I was showing the rights violations. I was showing that I had all their evidence stacked up against them. And, the more the judge tried to shoehorn me into their jurisdiction, the more I bucked the system and said, wait a minute here. There's nobody here actually making a valid claim that I've done them harm or damage. And then I used the transportation code showing, can they show by any means that I was engaged in uh, bringing transporting people for profit and gain or products for profit and gain. They knew they couldn't get out of it. Now, this was quite some time ago. Uh, you've seen how they've tried to change the word driver now. I've got a lot of evidence on where they're misapplying the statutes and codes, and that's something I really can't get into
certainly.
on
So
this. It was something that I could
let's talk
show.
about this. I got another question for you.
Sure.
When you first serve everybody with your notice of intent to sue, notice of liability, uh, did you seek out the agent for process of service? Did you just serve the Secretary of State because that is the agent for process of service? Did you notify the Attorney General of the criminal offenses and give them an opportunity to bring criminal charges before you brought a civil action? What was the process and what was going through your mind when you did that?
At the time that I went after Houston, uh, I knew that I had to go to the Attorney General. I also knew that I had to go to the Secretary of State. So I did serve them, and it was what I called a cross claim that I have done. They have no evidence that I have done anybody wrong or harm, but I showed them all the evidence, and I used their own statutes and codes against them, and it was undeniable. So that was the reason why the judge wanted to be real nice with me after he knew that I wasn't going to bend or break. And I showed them the little green and white things that I had already served, those that were required to be served. And I simply asked, who's going to indemnify me?
So you served them via certified mail, so you had a 3811
It
green
was
return
registered mail. It was
registered mail.
registered
Okay.
mail that
The
I
label
used.
200 registered mail. And
Yes,
then, of course, it sounds to me like you didn't bind it over to federal, that you, in fact, were doing this in the county court and you were doing a counterclaim under Federal Rule Civil Procedure 13, mandatory counterclaim, which means that you get to go first in bringing forward your juxtaposition and argument. And they capitulated after you had proven that they didn't have the substantial prerequisites meeting the
correct.
element of being able to charge you under the transportation code, which means they violated your unalienable right to egress, regress, and ingress as you see fit, declaring an emergency on the side of the road, and the officer committing about 25 felonies on the side of the road, just initiating
Absolutely.
his traffic lights and getting out. He engages in extortion, via disarms, aggravated identity theft, so on and so forth. Did you bring up any of those issues? I
I
noticed
did.
earlier you made the comment that you use their information against them
Right.
as
And I
evidence.
also, I don't mean to cut you off, Derek, but what really frustrated him is when I stated that, the police officers already said and agreed that an ex parte meeting with the judge and prosecutor happened without me, the accused. And that's what really made them nervous. They're like, oh shit.
So how did you get that on record? Did you get that on record through deposition, in a form of an affidavit? I mean, how was that presented? How did you
through
find out
through
that
my
information?
questioning, that was me deposing the police officer. That was he admitted it. The police officer admitted it, and they had no recourse to cover up what the police officer said.
So when you're deposing somebody on the record, do you notify the court to note that on the record, the official record? Um,
Absolutely.
okay, and what is the process of doing that during deposition? Do you stop mid-stride and say, I want this sworn testimony duly noticed on the record that the agency has henceforth sworn under the pains and penalties of perjury that he has engaged in ex parte communication with the judge and the prosecutor, proving that the judge is biased and not a neutral party and a fact finder of the matter at this point?
Absolutely. And the way you do that is you just automatically say, Judge, I need it on record right now. This is exactly what's happened. And we're doing an unlawful proceeding right now because I, the accused, am supposed to be party to any meetings that go on. And for me to be excommunicated out, you guys are committing fraud on the court. And the judge knows that the next step I can do is charge him and have them recused.
So
So,
that's a substantive right violation then,
yeah,
correct?
absolutely.
As well as an unalienable right and a due process violation. So once they
Absolutely it
violated
is.
due process, they've lost jurisdiction if they have at
Absolutely.
all.
And when you're demanding to be indemnified for the harm and injury that's been caused you, uh, you're going to find when you have that much evidence against them on record. And I tell everybody, get your transcripts. And even like with the Marlena case, we had filming going on in that courtroom, and the stenographer even was committing a crime because they were not putting what was actually said on the record.
That brings
And
up another good point. Do you bring your own stenographer into the courtroom or just your own witnesses that are going to swear under the pains and penalties of perjury via affidavit and create
I
your
would I would suggest that you 3 days before a trial or a hearing, I would suggest that everybody go and put in to have press there. That's what you want to do. Not you don't have to get the stenographer, have the press available and say, here's a request for press to be present. And that's a very good way because the press will put it out there for you.
well under the First Amendment, the press is open to the courts are open to the general public.
But
So
you
my
you
question
do
for you, I
notice that
guess,
they're keeping cell phones out of the courtroom in a lot of these courts now, which is totally unlawful.
certainly, I guess my
We
question
are
for you
doing
is,
that.
looking back in hindsight, if there would be anything you would do different, would you give the court notice that you're bringing your own stenographer? I don't ask permission, I just tell them.
Well, I would say that's a valuable thing to do. Absolutely. You definitely do not want to be in that courtroom by yourself. And people that have been in the courtroom with me, I walk in and I got 150 people with me. Now, I know not everybody can do that, but when you've got 150 people with you and all of them got their cell phones out and they're recording, judges get a little antsy. They don't like that. And when you start going after the prosecutor and you start going after a police officer on the stand, they get antsy. And I will
Well,
tell you, do not walk into a courtroom by yourself because, A, there's no telling what can happen. And I know for a fact that, they will do you harm if you go in there alone. If
you,
nobody knows you're in there.
you've mentioned a couple times about being indemnified, but it is a fact that anybody that brings a claim must bond the case to ensure the opposing party is made whole in the event they can't prove their claim. So, have you ever demanded the bonds and the affidavit sworn to with a verified criminal complaint
Yes,
for
that's
them to
one
have
way to go.
standing?
That's one way to go, but you can also go after their bonds. And you've heard me talk about how I've done this before, is I will go and bring up their charter and show that they're supposed to be bonded. Then I will notify the court that I wish to be indemnified because I'm going to give them 72 hours to cure the problem. And then otherwise, I'm going after their bond. Then, when I file against their bond, I give the bonding agency 21 days to indemnify me or uh, basically I'm doing a sworn affidavit claim against the bond. And that bond, they have 21 days to rebut in the form of an affidavit. If they don't do that, uh, then the bond is automatically supposed to be given to me. And then I will make a claim against the bond again, give them 3 days to respond. That, okay, an unrebutted affidavit will stand as fact in court. So when they don't uh, get back with me and say, okay, well, this is incorrect in the form of an affidavit, then I'll make a claim against the bond.
And they never do that. They'll never rebuke or rebut in a counter affidavit
They,
point by point,
they're going to
rebutting
hold
your
themselves
affidavit.
more liable. They
Mhm.
they realize, and then the bonding company, if they're, you can go after their license if they don't indemnify you, and you make that clear to them because they have to be licensed to be a bonding agency.
Well, the law clearly states in the Constitution before anybody can bring a claim that they have to bond the case. And so by them not having that bond, they're derelict in their duty. They're engaged in maintenance, circuitry, baratray, simulated legal
Right.
process using sham pleadings that are not certified or verified. We're not asking for verified pleading, verifiable pleadings. We're asking for verified, meaning they've already been verified, sworn to
Right.
under the consequences of
And
perjury.
you educate people on the SF-95s. I've heard you talk about it quite a bit, and that's these are all remedies that you can start trying to utilize. And I would suggest that you stick with the common law process of torts, or go after their bonds. And
Or bar grieve them, bar grieve them up their yin yang. Yep.
true, true. And when you're making a tort claim, that's you're sticking with the common law process. I like that. And the other thing that we're looking at, and I've been speaking with Pam Bondi on this, and what we're looking at with a lot of these courthouses that are for-profit corporations, we all know this, is going after them in the federal courts under RICO. So I have not perfected this yet, but I'm working on it. So when I'm successful with this, I'll draw out the process for everyone to follow.
Certainly. Um, in your endeavors, have you found that uh, you don't have as much interaction with law enforcement in such a negative connotation anymore?
I have made more friends with county sheriffs across the nation, especially during the scamdemic. I had sheriffs calling me and saying, "Well, Mr. Martin, how do we go up against the governor?" I said, "Well, the governor, the mandates are unlawful, and if they try to shut down, arrest the governor." And I was
Right.
praying that we would have. The first one that I actually went after was uh, Greg Abbott of Texas. And I was dealing with Ken Paxton. I said, "This is totally unlawful." And I was not a big friend of or fan of Barr, the attorney general at the time. And it was amazing that when I started talking about bringing claims against these governors, it was like the very next day that Bill Barr came out on the national stage and literally warned the governors that they didn't have the authority to push these mandates, but they did it anyway.
So Barr was removing himself from personal liability
Absolutely, he was.
by letting everybody know that he didn't want to be a part of
The
carrying
shutdowns.
the primary active degree of fault amongst joint tortfeasors by letting everybody know. So he's passing it out up the chain of command and stuff, saying, "Hey, this is innately wrong." It's important to understand that a mandate is nothing more than an offer to contract. It's not a law. It didn't go through legislation. It didn't go through Congress. And I'm going to show you guys that even if it did go through the House of Representatives and Congress assembled and through the legislator, it still doesn't affect you.
It doesn't make it law. Legislature, okay, especially when it violates regular, I mean, if it violates the Declaration of Independence, it can't be. I mean, I love Marbury versus Madison, the 1803 case. I love that case where it simply says any law, and how's a law become law? It gets voted on by legislation. Any law that's in clear violation or repugnant to the Constitution and the Declaration of Independence, it is not law. And these statutes and codes are not law. So any legislation that is in violation and repugnant of the structure of our government, which is a self-governing people, it's void. It's wholly void, ab initio. So when we get to that point and say, show me by what authority, that's been my line for over 30 years. Show me, judge, by what authority. And they can't give you the authority that they have that. If it's in clear violation of well-established law, as far as the Constitution and the Declaration of Independence goes, it's void.
So if they can't show you the law, they acquiesce by tacit agreement that you're correct in your assessment.
Absolutely.
And therefore, they lack standing to proceed. And they don't have
Absolutely.
jurisdiction, they don't have venue, and therefore, the claim must be dismissed for a claim being filed for which relief cannot be granted.
And somebody needs to indemnify me for the harm and injury that I've suffered.
Right.
And I can bring forth the claim.
Forward.
Right.
Mhm.
I can bring forth that, hey, I spent the night in jail. My automobile was broken into. I was yanked out. You know, I was I was assaulted. And if you look at it, police officers always got a weapon on them, correct? So that's aggravated assault and battery. And you start making claims like that. Listen, I don't want to harm my brother for his ignorance, but his ignorance is actually harming we the people. So sometimes it's best to make those claims and to do it in open court and say, hey, show me where they had the authority. And they can't do it. So
I'd like to open up the floor for questions and for Rick Martin. If anybody's got any questions, please be mindful and respectful. Let's try and stay on subject matter of traveling and pressing your claim. Anything that's pertaining to the court and proceedings. Rick handles things a little different than I do. Like I said, it's not right and it's not wrong. I'm not declaring it wrong or it's the right way. It's his way, and he's found a tremendous amount of success in doing so. Dana, go ahead. Dana, I see you have your hand raised.
Can you guys hear me?
I hear you, Dana. How are you today?
Hey, Rick, how are you? So my question is basically, the same situation happened to me. I'm currently trying to get my state case over to federal because the so-called defender was pretty much acting like a prosecutor when I was asking her specific questions regarding how she could represent me. So my question is there a way to temporarily stop the selling of my automobile while I fight my case once I get it switched over to federal? Because that's what I'm really trying to do.
I would say you would want to file a notice demand to cease and desist, and then I'd also file an estoppel. And that's kind of how I would try to handle that case, is filing an emergency estoppel, because more harm is going to happen to you if they sell your automobile unlawfully. Now, wouldn't it?
Along with a notice of liability as well. You've been denied due process of law. Write this down. This is very important.
Yes.
You never had a pre-seizure hearing nor a post-seizure hearing. And according to the Fourth and Fifth Amendment, you cannot be denied your life, liberty, pursuit of happiness, and enjoyment of property pursuant to the Declaration of Independence. In the Fourth Amendment, you can't be denied your property, paper, houses, and effects without just compensation. You were neither provided just compensation, nor were you afforded due process of law, which is a violation of your unalienable rights. Before they took your property, they had to have a pre-seizure hearing and a post-seizure hearing afterwards to prove that they had standing and the jurisdiction and reasonable articulable fact to support their reasonable
claim.
articulable suspicion in order to take your property, period. So
So,
those are the grounds that you can petition to the federal court for your redress of grievance. And the estoppel is the fact that you were denied due process of law. Therefore,
Absolutely.
even if it was legal and lawful what they did, because they denied you due process of law, they can't move forward because in the first instance, they violated the law by violating your unalienable rights, and they're in breach of their fiduciary duty, which is
Right.
to protect your life, liberty, pursuit of happiness, and enjoyment of property. Everything else they're doing is arbitrary and capricious if it isn't to bolster and protect your life, liberty, pursuit of happiness, and enjoyment of property. So you have a petition to the Supreme Court of the state, the federal Supreme Court of the state, to get an emergency injunction and estoppel. And a
Right.
lot of times the clerk of the court of the Supreme Court will handle that for you. You won't actually have to go to a hearing or anything like that, but you need to notify the lower court of your petition to the Supreme Court. And you also need to notify the county or the city that took your property of their notice of liability to cease and desist, that they denied you due process of law, that any further action, the caveat can state, will cost them $1 million for every additional day that they continue to deprive you of your life, liberty, pursuit of happiness, and enjoyment of property. Under the Fourth Amendment, you haven't been justly compensated. And this is at that point, if they continue to persist on, now you have your solid ground and foundation for pressing your claim